May it please the Court, I'm Heather Sussna with the Appellate Defender Office here on behalf of Mr. Beaman, and I would like to request 4 minutes for rebuttal time, please.
4 minutes is granted.
Thank you very much. And my plan was to primarily discuss the jury trial waiver, the sentencing continuance, and to mention something very quickly about the electronic monitoring, and to submit the rest of the issues on the brief unless the Court has specific questions about those issues. Since my comments about the electronic monitoring are really quick, I'll start with that first. After reviewing the sentencing transcript in this case and the Longbind case, which I believe is the unpublished Court of Appeals case that the state cites to on their electronic monitoring issue, I would not have a problem if this Court were to adopt the rationale in Longbind and say that under the facts of this particular sentencing that really what the judge was doing was not actually imposing the electronic monitoring, but merely advising him per the state's request that he was subject to it, which he clearly is under the statute. So I just wanted to throw that out there for the Court before I move on to my other issues. Let's start with the jury trial waiver issue. I think the standard of review for this Court is whether or not basically whether or not what the judge said at the jury trial waiver was sufficient for my client to effectively waive his right. That's subject to unlimited review on appeal.
Before we get there, can we talk about preservation? Because
Sure.
I'm bothered a little bit by that,
Sure.
frankly. And what bothers me about it is that at the district court level, not only did it not come up as an objection, it came up as a benefit for the defendant. It was mentioned in the departure motion that he had waived his jury trial right. It was mentioned in the oral argument on the departure by both the defendant and counsel. And it seems to me that this is one where, what are we doing here when they argue it as a benefit and why they're good guys at the district court, and then on appeal we come up and go, whoa, there's reversible error.
Well, and let me address the fact that it was argued at the departure motion and that it was brought up later on, as I think once it happens, defense counsel's in the position of they're going to use it as best as they can. I think it was clear from the record that defense counsel was actually opposed to the jury trial waiver in this case and that the defendant attempted to go through with it anyway against counsel's advice. But I think, as a defense counsel, once you're in that position where it's already been done, I think you need to make the best out of the circumstances that you have. So I wouldn't necessarily use the fact that it was used in the departure motion to say that this is somehow invited error on appeal. I think, like I said, you have to deal with the reality of the situation once it happens. As far as the preservation issue, with the fact that it was the defendant's request to waive his right to a jury trial, I know the state cites to the Luna case as a preservation problem in their brief on this. My argument is essentially that even though this wasn't objected to below, and this is raised for the first time on appeal, that this is a fundamental right. I don't know that you get much more fundamental in our criminal jurisprudence than to say that the defendant has a right to a jury trial. And for that reason, I think this court has an obligation to address, even for the first time on appeal, even where it appears that this was the defendant's request. And let me come back to the defendant's request here in just a second as well, because I think that's important. But I think it meets the exceptions for raising it for the first time on appeal. So I don't think we have a preservation problem as far as whether or not you can address that. And again, the fact that it was mentioned later I don't think becomes an invited error problem. And this is going into addressing your question, Your Honor, and also going into sort of the merits of the jury trial waiver issue here. I think part of the problem with the jury trial waiver in this specific circumstance is that it appears from the conversation that was had by my client at the waiver discussion that he was confused as to what exactly he was doing. I mean, there are definitely some areas in this conversation where he's saying that he wants to take responsibility, that he doesn't want to put the defendant the victim and the family through a trial. I mean, it sounds almost like he's actually trying to plea as opposed to even having a bench trial. And I guess that's part of the concern here, is that because of the district court's lack of information about what exactly he was trying to waive in the first place, and the fact that the defendant seems confused as to whether or not he even wanted to go to a bench trial as opposed to a plea, let alone waive his jury trial right. I think this rises to the level of concern that the district court didn't do enough in this circumstance to fully inform him of the right he was waiving and to make sure he understood that right and that it was properly waived. So, I mean, I think part of the problem here is also that the defendant appears to be confused, and the judge addressed the fact that he appeared to be confused on the record, and our argument is basically that he just didn't go far enough.
And really made sure that he wasn't confused
by
saying, you know, these guys are still going to have to testify. They're just going to do it in front of me. And the defendant went back and said, yeah, I know that, and I want them to do that because I would rather have this in your hands. I would rather have someone of your experience judging my defense, which is, yeah, I did it, but I didn't think she was as young as she was, or whatever. You know, I can't quite get the rest of that. Right. But, I mean, there seems to be a dialogue of understanding between the defendant and the trial court, which is then repeated at the departure motion and at the sentencing proceeding. And that's where I just don't understand what you're pointing to that shows confusion on the defendant's part about what was happening here.
Well, again, I think the defendant specifically made statements that he just wanted to take responsibility for this, which indicates almost a desire to plea as opposed to even going to a bench trial, which makes me concerned that he didn't understand even the difference between the jury trial, the bench trial, and potentially just pleading out as charged, which also was an option for him if he wanted to. I think the other thing to point to is I know you just reiterated sort of some of the conversation between the judge. With all due respect, actually, what if you go back and reread that conversation, the judge, my client has said at one point, I don't want to have to put the victim and the family through a trial. And the judge says, okay, well, they're still going to have to the victim's still going to have to testify just to me, not to a jury. And my client's answer to that was, That was the extent of his answer at that point. And I'd be happy on rebuttal to grab that record site for you. He does, like I said, say he wants to take responsibility for that. Again, I think that rises to the level of questioning as to whether or not the judge did a good enough job in informing him what it was that he was waiving. And the part of what I wanted to make a point of today on the jury trial waiver issue here is that I think because certainly Ms. Lakey and I are attorneys, and all of you are attorneys too, we're all very well versed in the idea of what constitutes a jury trial right. And we use the term jury trial and a bench trial as shorthand. And I think sometimes we forget that we use it as shorthand and that there are really specific things that come with a jury trial right, that the defense attorney gets to help pick the jury, that there's 12 of your potential peers, that those people, all 12 of them have to be unanimous as to your guilt beyond a reasonable doubt. These are all things that I think Joe Schmo off the street, if you were to ask him, do you want a jury trial, do you want a bench trial? I don't know that you can just assume without the district court informing him of those rights that he actually understands them. And I think that is part of the problem in this case is that I don't think the district court, and I think the district court had an obligation under Irving, I don't think the district court did a good enough job of informing him of the nature and the extent of the right that he was attempting to waive, sufficient to ensure that the conversation that they were having was not, was enough to make him knowingly and voluntarily waive that right.
So you're saying that Irving's requirement upon the district court to affirmatively explain the jury trial right means something more than discussing strategy.
That is correct. And I will say that I think part of the problem here is that it was clear because the district court acknowledged that that Mr. Beaman was doing this against counsel's advice. I think everybody probably understood that there was obviously a conversation that occurred off the record between Mr. Beaman and his defense counsel about the advisability of waiving his right to a jury trial. However, I think this court has made it very clear that regardless of the conversation that occurs between the client and counsel, the district court still has a duty to inform him of that right on the record. And that's what we're missing here. And then you add to that fact his statements about wanting to take responsibility, about not wanting to have the victim testify, and then even though the district court then says, but they're still going to have to testify, and he says, I mean, I think taken together, it rises to the level of really making his waiver questionable in this case. And our argument would be that it didn't satisfy the basic requirements under Irving. If there's no other questions on that issue, I'll go ahead and move on to really quickly to the continuance for sentencing issue. I know I'm getting low on time, but the problem that we have here with the continuance of the sentencing is that defense counsel walks in and says, I know that this is a Jessica's Law case, and there's also the on-grid non-Jessica's Law account of the aggravated indecent liberties in this case that involves lifetime post-release as well. And defense counsel walks into the sentencing and says, I need a continuance. I know there's this cruel and unusual argument out there. There's proportionality that I need to investigate. I want to be able to raise this. And the district court basically says, well, I think you can raise that on appeal. And then the defense attorney tries to say, I don't think I can raise that on appeal. I think I have to raise this below. And basically the district court then says, well, I don't think that this is worth a continuance and we're going to move on. And so defense counsel then is sort of in this between a rock and a hard place and throws up at the wall during the sentencing hearing later just a kind of a vague reference to the hard 25 being cruel and unusual punishment on the Jessica's Law charge in this case. And the district court discusses some of the facts during the sentencing hearing, but does not, but that's all in the context of the departure motion, and does not actually rule on the cruel and unusual argument below. And so our argument on the continuance is that whether you're using abuse of discretion standard or whether you're using a question of law standard, I think either way, this is error because obviously, as this court is very well aware, these Jessica's Law cases and the lifetime post-release cruel and unusual argument on the non-Jessica's Law cases is an extremely litigated issue that we've been up on many, many times. And so I think under those circumstances, the defense attorney coming forth and asking for more time to be able to investigate this cruel and unusual proportionality, that the district court erred by failing to give him a continuance for that, because then it's not properly before this court.
Why couldn't the defendant get it? I'm sorry. Why couldn't the defendant get it done between the date of conviction and the date of sentencing?
Your Honor, that is
the 18th of September.
That is a very good question, and my response to that is that he doesn't present any evidence as to, he doesn't make any statement as to why he only recently discovered that this was potentially out there. I will say that I think this court can look at the conversation that happened between the district court and the defense attorney and acknowledge that the district court didn't seem concerned, and I don't know if that's because the district court maybe had this attorney practicing in front of him on other cases during that time and knew he was busy. I don't know what the district court knew, but for whatever reason, the district court was unconcerned with the fact that he had 2 months prior to the sentencing to do this research and hadn't done it. The district court was much more focused. I'm sorry, I didn't mean to interrupt. The district court was much more focused on whether or not this court had previously found these cases, these types of arguments unconstitutional, and seemed to think it wasn't a valid reason for a continuance based on the merits of the argument, as opposed to whether or not defense counsel had a reasonable time to have done this before coming to sentencing.
The district court may have understood that, but how are we to make that without a record? Where's the record that we can rely on to show that there was good cause for a continuance?
Well, and I think that you can rely on the fact that the district court was making the ruling based on the actual issue, as opposed to any concern over the defense attorney's failure to have been able to do this ahead of time. I think you can infer from the fact that that wasn't the basis for his decision and use the basis for his decision, which was primarily that this was not an issue that needed to be continued because it wasn't something that counsel needed to really work on, essentially, and say that that's an abuse of discretion without necessarily needing to consider whether or not he had previous time. Does that make sense?
And of our general rule of abuse of discretion, we've kind of broken that down to at least 3 different categories of how a judge can abuse his or her discretion. It sounds like you're saying the judge failed to properly apply legal principles because the judge incorrectly said, just raise it on appeal, therefore I'm denying your motion? Or where are you going?
I'm sorry, I didn't mean to interrupt. I believe so, and the reason that I'm saying that is that you have to remember the sentencing occurred actually before Seward came out, so it wasn't necessarily well known that the defense attorney had to force the court to make specific findings of fact, but certainly the cases like Ortega Catalan, those cases had already come out saying that it needed to be addressed below first. So I think that law was already out there, and even if defense counsel wasn't armed with that to tell the judge, I think the judge should have been aware of that law. And the other, I hope that answers your question, Your Honor.
It does.
Yeah.
Any further questions of counsel?
What was the timing? This was summer and fall of 2009.
I believe the bench trial was in July of 2009, and I believe sentencing was around like September.
No, I meant in relation to Catalan.
Ortega Catalan was in 2008. I think maybe October. I'm not really sure about that. I know Seward came out, I think, maybe a couple weeks after this sentencing was held. So even if he would have gotten a couple weeks continuance, that may have made a huge difference as to whether or not the proper findings were made and whether or not the actual cruel and unusual arguments would have been in a proper position to be raised at this court.
Anything further, counsel? I see none. Thank you, counsel.
Thank you, Your Honor.
May it please the court, Cheryl Lidke on behalf of the state of Kansas. I'm just glad we don't have a 6455 issue in this case. We argued under issue number 1 that this is not properly preserved for appeal. We really don't see any difference between this and Luna. There was no issue raised in the lower court. There was nothing in the docketing statement on this appeal that this issue was going to be raised. And so we would ask that you find that it has not been properly raised or preserved for appeal. We do recognize, however, that there is a Court of Appeals decision that conflicts with the Luna decision on that. And so for that reason, we address the merits. We disagree with the standard of review that counsel has just espoused to you all, and I believe she said it's a de novo review. My understanding of the Bland case is that the standard of review on this very issue is if there is substantial competent evidence to support the lower court's finding that the defendant knowingly and voluntarily waived his right to a jury trial, then this court should affirm that.
What's the substantial competent evidence that the trial court did so?
The dialogue.
Justice Biles, called it a dialogue, a conversation. Shouldn't it be a little more formal than that?
Well,
in a plea, and I appreciate a plea as a waiver of a trial,
sure.
A jury trial.
And the problem,
we require a lot more than that. And
right.
in this, there's nothing about how is the court satisfied that he understands what a jury trial entails and what the rights are? And this to follow up, I also have a concern that he disclosed that he's prosecutorial or prosecution oriented. I mean, the whole conversation just lends itself to it's more of a kind of give and take conversation rather than an appraisal of rights.
I think the problem that Judge McNally had is that there is no case law in our state that I could find that tells the court what steps it must go through to make sure that this is a knowing and voluntary waiver of a jury trial. So I think Judge McNally did the best that he could in making sure that the defendant understood the value of having a jury trial and the consequences of not having a jury trial. And we have some guidance, I think it's in the Simpson case that looked at a Florida decision where it said as long as you're explaining to the defendant the value of having a jury trial versus a bench trial, and you explain to him the dangerousness or the disadvantages of giving up that right to a jury trial, then that seems to be sufficient for this court to later then say, well, there's substantial and competent evidence that the lower court did, or that the record shows that it was a knowing and voluntary waiver of the rights. If you look at this dialogue between Judge McNally and Mr. Beaman, I think the record is clear that the defendant understood the value of having a jury trial versus a bench trial. Judge McNally couldn't be any more clearer. You know, sometimes we judges, after a period of years, become prosecuted minded or more likely to agree with the prosecution. So you are basically disadvantaged by putting your your fate in my hands instead of a jury's hands. And yet Mr. Beaman, after being told that explicitly by Judge McNally, said, I know, I understand that, but I'm still willing to take that chance. And I think that's what the dialogue goes on for some 3 or 4 pages. And I just think that is evidence in and of itself that shows that Mr. Beaman was crystal clear on the value of having a jury trial and what he was giving up by not having it. So we would ask that you find that dialogue to be that substantial, competent evidence to support the lower court's finding.
And so you're saying, because Irving said that a district judge has an affirmative right to advise a defendant as to the right to a jury trial. Here, I think the judge did a Herculean job of advising the strategy or the strategic reasons that you would want a jury trial. And am I hearing you say that that's enough? You don't need to get into any legal niceties or constitutional implications of the jury trial. It's enough if the judge has explained the strategy?
Well, I don't know that it's enough in every case, but I think in what Irving said was that in order for this to be, they said the test for determining the validity of the waiver is whether the waiver was voluntarily made by the defendant who knew and understand what he was doing, and it's going to depend on the particular facts of each case. And since Irving, we've not had any case tell us, what exact steps that a judge must take. But we have had other cases like the Simpson case where they say that, well, if the focus is on explaining the value of the trial and the disadvantages of not having the jury trial, then that seems to satisfy this Irving test. So I don't think that Irving says anywhere other than saying that it has to be on the record and explicit what steps that the court has to take. My comment regarding issue number 2 is that how can you say that a judge abuses its discretion in denying a request for continuance when the defense attorney is very vague, speculative, ambiguous about why he needs that continuance? What Mr. Lubo said was, well, Judge, I might file another motion. I might possibly put this in as another issue for you to consider. He never said with any concrete or solid explanation why he needed more than the 2 months that he'd already had. And I think under those facts that most people would agree with Judge McNally.
But do we make that determination? Do we look at it and say, well, if we were the judge, we'd have done the same thing, or we look at the facts and say, well, it wasn't enough? We just review the district judge's rulings, and the ruling here was you can raise that on appeal. All of these are going to have that issue going up on an appeal for Jessica's Law, something to that effect.
I think the question for you is, could reasonable minds agree with Judge McNally's denial of the request? And I think absolutely.
But we've said that if the judge applies the wrong legal standard, that by definition is an abuse of discretion. And if the judge was exercising his discretion on whether to grant a continuance based on the fact that it wasn't going to foreclose that issue for the defendant, to me that's huge. I can't say that wasn't prejudicial if it meant the difference of you got to get the issue heard on appeal or you didn't. And I took the judge's comments to mean that he thought by denying the continuance he was not foreclosing that issue for Mr. Beaman.
I don't think that you can conclude that that was the only reason that the judge denied the motion for continuance. He may have said to him, and by the way, you're going to still be able to raise this on appeal. But I think the judge took into consideration everything. The fact that 2 months had passed, the fact that he was only being speculative in his arguments for a continuance, that he might do something that he hadn't already done. So to say that Judge McNally only denied the motion to continue because he felt like it was not foreclosing the appellate issue, I think is incorrect.
What were the reasons stated on the record by the judge for why he was denying the motion, other than you can always raise it on appeal?
Well, he gave me an opportunity to argue, and I raised the arguments that I've raised here in my brief. So I'm hopeful. I can't remember what the transcript says, Justice Nuss, but I'm hopeful that he said that he was considering everything that had been argued by the parties.
Wasn't there a reference to the courtroom being full, that people were ready to go?
Oh, yes. Yes, there was.
Which kind of implies you had time and we're here. And
right. That's correct. I mean, I don't think that there's... I think you could say that that was maybe the only reason for his denial of the request, but I don't think it's the only conclusion that you can make from the record in this case. The final issues, I think you'll see from our brief that we do concede on issue number 5 that it should be lifetime parole on count 1, which was the off-grid offense. We do not concede that on count 2, obviously, because it was on the grid, and we think post-release supervision applies to it. I don't think remand is necessary, though, if you're going to change that as it relates to count 1. I think I've read an opinion from this court where it basically just said it needs to change to life parole instead of lifetime post-release, and it was not remanded for resentencing. I think that's just an administrative thing that the Department of Corrections will do once it sees your opinion. And I'll just rest on my brief on the rest of the issues unless there are other questions from the court.
One thing struck me as I was going through here. I think it was in respect, well, no, it was with respect to the departure motion. The judge made the comment, this is exactly the kind of behavior that the legislature intended to prescribe. And it was my understanding we had a child here that was in between her 13th and 14th birthday that, and my understanding of Jessica's law is that that name came from the Florida case where the young child was beaten, murdered, and raped, and that Jessica's laws generally refer to crimes committed on children under 12. Am I misunderstanding what the generic label Jessica's laws mean?
I think in Kansas, Jessica's law means for crimes committed to children under 14. And I think that's what Judge McNally meant. Our interpretation of what Jessica's law is.
It's just the age and the fact.
It becomes off-grid.
The other facts that were specific to Jessica Lunsford, where it was a brutal, forceful, violent act rather than a consensual act between someone right before they were 14.
No, I don't think Judge McNally was talking about Jessica's law as it was passed in Florida. What he was talking about was the Kansas law as it's been passed in our state. Prohibits any sort of sexual contact with a child under the age of 14. And because the defendant and several members of his family had made comments that, well, she was almost 14, I think Judge McNally took offense at that and said, look, our legislature has determined in what we call Jessica's law, this is illegal to have, and it's a higher offense when she's 13. And she was, in fact, 13 during one of the incidents.
How old was the defendant?
43, wasn't he?
I was going to say in his mid-40s.
Okay.
Yes. Are there any other questions?
Any more questions of counsel? Any further presentation? I see none. Thank you.
Thank you.
Reserve 4 minutes for rebuttal.
Thank you, Your Honor. Since there were some questions about exactly what the judge's ruling was on the motion for continuance, I just wanted to point the court to Volume 3, which is the sentencing hearing, pages 7 and 8. And basically, at that point, the judge asks the defense counsel, so what is this sentencing issue that you want to look into? And the defense counsel explains that it's cruel and unusual and that it's been raised in other cases. And the court says, and this is the bottom of 7, well, certainly that's something that you could raise on appeal. And the defense attorney goes through and says, well, I think that the court has said that it has to be raised at the trial level. And the court then goes through and says, and the defense attorney has said that he wants to research the proportionality. And the district court, and this is on page 8, says, Mr. Ludlow, I don't really think that that's a reason to delay this sentencing. As I say, it's an issue that is going to be raised in every Jessica's Law case until the Supreme Court decides it. But I don't see it as a basis to continue the sentencing in this matter, so your motion is denied. That was the only reason that the district court gave. And I think that while certainly the prosecutor made the other arguments, both on appeal and somewhat below, that was the only reason that the judge gave. And I think that that's what this court has to decide the continuance issue on. Other than that, if the court has no other questions, then we would simply ask that Mr. Beaman's convictions be vacated and his case be remanded for a new trial.
Do we have any further questions? I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning and this afternoon. The court will take this matter under advisement. This time the court is in recess until 9 o'clock tomorrow morning.